Good afternoon, everyone. Welcome to the Appellate Division First Department. You guys know the spiel. So it says almost 6 hours of argument time requested for Wednesday, September 20th, 2023. Not happening, right? Okay, so long as we understand that. So we've read your briefs, we know your arguments, we are fully familiar with your arguments, probably more so than you'd want us to be. So please, just ask for the time that you actually need to get your salient points across to this panel. People v. Raymond Robinson. I'm sorry? 5 minutes. 414. Enholm versus Amco 240 West.
For the appellant, Your Honor, 4 for the main and 3 minutes for rebuttal.
For responding, 5 minutes.
Yeah, 4, 1, and 5. Linnea versus Matthew P. Submitted. People v. Abel Echeverria. 414. Newell versus Javier.
Respondent, 4 minutes.
I don't see an appellant. Did you wish to submit? Did you wish to submit? I do not see an appellant.
In that case, yes, I'll submit.
Excellent. Thank you so much. That matter is submitted. Beer v. Beer.
For the defendant, appellant, and respondent on the cross appeal, 8 and 4.
For the plaintiff, respondent, appellant, 5 minutes, Your Honor.
6 and 2 and 5. People versus Jerry Calderon. Submitted. Van Horn versus Ben Dove.
4 and 1, please, Your Honor.
Who are you?
5 minutes, please.
414. Lucas versus Verizon Communications.
For the appellant, 10 and 2, Your Honor. For the respondent, 6.
5 and 2 and 5. Lopez versus the New York State Office.
If the court has any questions, I can take 3 minutes to answer them. If the court has no questions, I can.
You're the respondent. Any questions? That matter is submitted. Thank you so much. Maria versus Andre. That matter is submitted as well. 45-47-49, Eighth versus Conti.
For the appellant, Your Honor, request 8 and 4.
For the respondent, Your Honor, requesting 8.
525. People versus Marie Jordan. That matter is submitted. People versus Jacob M. That matter is submitted. People versus Alexia Williams. That matter is submitted. Diaz versus the State of New York. I'm sorry? How much time did you wish?
7 minutes and 2 for the respondent, 5 minutes.
414. People versus Kevin Sales. Matter is submitted. I'm sorry.
For the appellant, 4 and 1. For respondent, Your Honor.
414. Wagman versus Morgan Stanley. Submitted. Fifth Avenue 25G versus Sambar. Submitted. First case on for argument, People v. Raymond Robinson. Yes.
May it please the court, Gwendolyn Parrish with Office of the Appellate Defender on behalf of Raymond Robinson. 15 years is just too much. As this court's cases have made clear, because Mr. Robinson, a person who has never been arrested—
What would be sufficient?
I'm sorry?
What would be sufficient? You said 15 years was too much. What would be sufficient under the circumstances?
Your Honor, the cases that this court has decided before tend to fall in a 5 to 15 year range for an indeterminate term, since this is a determinate—
Oh yeah, he was charged with the man 1, right? So the minimum is 5. Right?
5 years, yes.
Yeah.
We would ask for something closer to the minimum.
Closer to 5. So refresh my recollections as to the facts of this case. What happened?
Yes, Mr. Robinson was on the playground with his 4-year-old son. The victim in this case shot and almost hit his son as he was coming down the slide. Mr. Robinson went and retrieved a
So
firearm.
Mr. Robinson then leaves the playground, goes home, retrieves a gun, comes back to the playground, and then fires at the victim. Is that correct?
Yes, Your Honor.
And this is in the evening, right?
Yes.
What time is it?
It's around 7 p.m.
7 p.m. And this is a playground, which by definition means they're children. Is that correct?
Yes, Your Honor.
Yeah. And so you believe that under the circumstances where he discharges a weapon after going home to get that weapon, he comes back to the playground, discharges the weapon, shoots the individual, could have shot other individuals who were on the playground, that 15 years is too much time.
Yes, first of all, I want to say that we are not trying to minimize the gravity of what Mr. Robinson did here. But we do want you to look at these two cases, in particular, Fernandez and Matias. In Fernandez, Mr. Fernandez was assaulted by the victim in the lobby of his building. He went home, he got a knife, he took some time to try to stop the bleeding of his nose. He returned and he stabbed the victim and killed him. And this court has recognized before that in cases where somebody experiences something very traumatic and they leave and they get a weapon and they come back and they kill somebody, it is possible that you can look at it and see that there's the potential for a sentence reduction here. Also,
Counsel, did
yes.
your client waive his right to appeal?
Well, the appeal waiver was not voluntary in this case.
Well, let me just ask first. Did he execute an appeal waiver?
Well, he had agreed, yes, on the record to
did.
waive his right to
And
appeal.
there was a colloquy on the record about the appeal waiver?
There was a colloquy.
Okay.
But, Your Honor, that is only one of 4 factors that Thomas asked.
Was he able to, it was a remote hearing, correct?
It was a remote hearing.
Was he able to have a confidential conversation with his counsel with respect to the written waiver?
No, he wasn't, and that is
And
why
does that, so what's your position with respect to that?
it wasn't voluntary. And Thomas requires us to look at 4 different factors when we're trying to figure out whether something was voluntary on the face of the record, and that is experience in the criminal justice system, which Mr. Robinson didn't have. Consultation with counsel, Mr. Robinson obviously didn't get that chance for a private conversation with his counsel. Acknowledgements of understanding. These were one-word responses during the colloquy. Yes, I waive my appellate rights. And whether there was a written appeal waiver, which there wasn't. And so under the circumstances, we have 3 factors here where it weighs against voluntariness. I see that my light is on.
Yes, you have time on rebuttal.
Thank you.
So, counsel, in terms of the waiver, I thought that at some point in time they went off the record so that counsel could have an opportunity to discuss the waiver with her client.
Yes, Your Honor, and may it please the court. It is the people's position that it was voluntary, as well as the face of the record evinces a full appreciation of the consequences of the appeal waiver, because defendant, when first asked by the trial court, "Do you understand the appeal waiver?" he said no. He expressed the fact that he did not have an understanding. He was then given the opportunity to have a colloquy with his attorney. They spoke. The contents of their conversation are not on the minutes, but after that conversation ended and they went back on the record, the defendant stated that he then understood, after having discussed it with his attorney, the contents and the consequences of the appeal waiver. So he went from a mental state of not understanding it to a mental state of fully understanding it, and then he repeatedly affirmed his understanding of the judge's subsequent explanation.
So when they went back on the record, the court says whether he had discussed the waiver with his attorney, and the defendant said yes.
Yes,
right?
precisely, and we believe that that satisfies the Thomas factors for voluntariness of an appeal waiver.
And then the court went through various questions. you're asking to waive your right to appeal. Do you understand that? He said yes. Court talks about what an appeal is. Do you understand everything I've told you about an appeal? He says yes. So there was some colloquy which the defendant did respond that he did understand, and this was after they had gone off the record and he had presumably spoken to his attorney concerning the waiver.
Indeed, Your Honor. And so we believe that the voluntariness of the waiver and his full appreciation is established. However, we are also prepared to defend his sentence as being fair and not excessive.
How do you distinguish the cases, or at least the case cited by your adversary, that that there was a interaction, person goes, gets a knife and comes back and kills the victim, and that should result in a sentence reduction?
Yes, Your Honor. With due respect, it is our belief that defendant's counsel left out the fact that after retrieving the knife from his room in the Fernandez case, the defendant was trying to leave the apartment complex and the victim lunged at him. And in the immediacy of that attack, the defendant stabbed the victim and the victim died from that. That is very different from this matter with Mr. Robinson, where the firing of a pistol at the playground happened. There was a cooling down time. He retrieved his gun anyway and returned to the scene. There's no allegation anywhere that the victim again tried to attack Mr. Robinson or did anything dangerous towards Mr. Robinson, which is very different from in Fernandez, where...
But Mr. Robinson had never been arrested previously, is that correct?
Your Honor, while Mr. Robinson does not have a criminal record prior to this manslaughter incident, he had been arrested twice. In 2008, he was arrested for disorderly conduct, obstructing government administration.
Well, arrests don't count, right? An arrest means nothing, it's simply an allegation. He has no prior convictions.
Correct, Your Honor. However, his prior
So why would, I mean, he received the max, why not something in between or closer to the minimum as your adversary advocates?
Well, Your Honor, the maximum was 25 years, and he received a sentence of 15 years, which is pretty squarely in the middle of the minimum and the maximum.
Thank you.
Thank you, Your Honor.
You may proceed.
I would just like to respond briefly to the argument that his chance to talk to counsel was adequate. He didn't have the opportunity to ask sensitive questions that we are often, as defense counsel, asked of our clients.
How do we know that? I thought the counsel, my reading of the record, and please correct me if I'm wrong, it says, the court says, give you an opportunity off the record, because it was virtual, to speak with your client concerning the waiver. They go off the record, and then they come back on, and apparently they had spoken about the waiver. The question was asked. Yes, they spoke about the waiver. So I'm not understanding why you say that he was not given that opportunity.
Well, it was not a privileged conversation. We often get asked as defense counsel whether, for instance, what would be the risk if I said no, if I didn't waive my rights here. He couldn't have asked that. The DA was listening. And if I could just briefly turn back to the sentence. Mr. Robinson, this action was truly aberrational to his nature. He had a 10-year work history. He had no history of violence. It's clear that seeing his 4-year-old son almost get shot on the playground was so emotional to him that, this happened. He can't take it back. And he's not asking that he not be punished for this. He is simply asking that, he gets an opportunity to return to the community sooner, and he will be a successful member of
Thank
society.
you.
Thank you.
Thank you both. Engholm versus AIMCO, 240 West 73rd Street.
Good afternoon, Your Honors. Magda Cruz for the appellant, AIMCO, as well as the new owner. I begin by emphasizing that this apartment had become deregulated 14 years before the case was brought by these tenants.
And when did the landlord file regulatory status with DHCR?
At the time, in 2016, Your Honor, when the apartment was gut renovated, there was no obligation to file an exit
Well, my question is when? It was in
registration.
2020, correct?
The obligation occurred many years later, either 2014 or 2020. But at that point, Your Honor, the apartment had been, rented out to 5 market tenancies prior to these individuals renting the apartment in 2019. So there was no obligation at that time. This apartment, the record firmly shows, was deregulated by virtue of a gut renovation that occurred in 2006.
What was improper about the court saying there's an issue of fact on more discovery is needed to substantiate the allegations of the tenant that this renovation didn't really happen, which were substantiated by the tenant with the contractors?
So I would submit, Your Honor, that in fact the tenant never submitted any evidence really that showed that they were missing to make my client's motion for summary judgment premature.
Well, why wasn't the contractor's affidavit that the tenant submitted sufficient to at least raise an issue of fact, which would make summary judgment premature without discovery?
It was not sufficient for a couple of reasons. That individual that came into the apartment in 2022 obviously had no personal knowledge of what occurred in 2006. It could not override the
Yeah, but
affidavits
counsel,
that we submitted.
That's always true of every expert. This was a submitted expert affidavit, right? So if
Yes,
you
Your
think
Honor.
that it has no water, why not take the expert's deposition and then move to summary judgment after the close of discovery?
Your Honor, that's true. There can be cases where an expert does submit a very valuable affidavit.
And an
that
expert
raises
almost
issues of
never
fact.
has personal knowledge. You hire someone later on. But this
True.
expert said, I went in, I looked at the apartment. I did an inspection, I did this, this, and this. I don't think these renovations occurred.
True.
So at a minimum, why not just take his deposition? If you think it's based on nothing, then take the deposition and move for summary judgment at the end of discovery.
Because I think the Court of Appeals has really addressed that very same question that you're raising, Your Honor. I call your attention to the Boyd case, for example. In Boyd, they also had an expert affidavit that claimed that, in fact, the renovations had not occurred years prior to the tenancy. And I think the Court of Appeals, both in Boyd and then subsequently in Regina, has indicated that challenges to certain fact-based determinations of deregulation, I'm not saying all deregulations, I'm
So
saying
you're making a statute of limitations argument? Because that doesn't appear to be exactly what your argument was, why this decision was incorrect. I mean, now you're arguing a statute of limitations issue, but that's not the way this case was teed up.
it was certainly addressed below, and we certainly argued that you cannot challenge a deregulation 14 years later, and that the facts that we submitted cannot be challenged with such a prolonged
You
period
didn't
of
move to
time.
dismiss on the ground that the statute of limitations bars this action, did you?
We did not make a specific statute of limitations defense, but it is intertwined with the actual allegations of why this deregulation cannot be challenged. Because, Your Honor, it is not just the gut renovation, and I will sum up very quickly. I do want to
You can do
state-
that on rebuttal. Thank you.
Thank you, Your Honor.
Your Honors, David Hershey, Webb, Himmelstein, McConnell for respondents. Just to address the issue that was raised by the court regarding what they call exit registration or registering an apartment as permanently exempt. In fact, 2 of the cases cited by my opponent noted that as an important factor that the landlord had at the time. The landlord
What
allegedly.
about counsel's point that there was no legal requirement to do it at that time, so therefore, we didn't do it?
The courts have found it factors in, so it factors in, but there are other factors. The landlord or the appellant in this case simply didn't provide sufficient evidence of, number one, didn't provide sufficient evidence of having deregulated the apartment.
Well, why should we accept the contractor's affidavit as sufficient to raise an issue of fact with a contractor who you submitted the affidavit from never did see the apartment during the time of the renovations, was not involved in the renovations in any way? Why was that sufficient to raise an issue of fact as to whether or not the renovations ever took place?
Your Honor, two reasons. Number one, the contractor affidavit that we put in was from a contractor with 40 years of experience examining apartments, but qualified as an expert repeatedly in the courts. The evidence that for the primary contractor in this case, the $58,000 contractor, the only evidence submitted was an affidavit from a contractor today and an original contract. No invoices, no canceled checks.
Okay, but you didn't raise the issue for 14 years. What contractor is going to save their invoices for 14 years? That's ridiculous.
Yep.
So yes, you do the best you can, but why are we going back 14 years and saying, oh my goodness, the landlord doesn't have a 14-year-old renovation document?
Your Honor, there's no statute of limitations in regulatory status. But secondly, the owner came forward with quite a bit of evidence.
Exactly, more than you would expect, right?
Yes.
So why is your expert coming in and taking a look around and saying, this can't possibly have been? How does that raise an issue of fact when your expert wasn't there at the time? He doesn't dispute the authenticity of any of the documents that the landlord submitted, does he?
Your Honor, he found that there was work that wasn't done in the apartment. There was duplicative work. There were two contractors. There's no invoices for the primary contractor. The only invoices are for the $6,000 contractor, which the owner seemed to have. Affidavits of payment, waiver of lien, invoices, all for the little contractor. The big contractor, nothing, nada. In fact, the affidavit from, we'll call him the big contractor, the primary contractor, didn't even state which documents he reviewed to come to his conclusion. I looked at some documents. What documents? Because there were no documents in the record. Zero, zippo. There was a contract, not fully executed. No invoices.
As my understanding is there were no permits either, correct?
No, there were no.
Is there a requirement for a gut rehab to have a permit?
Your Honor, that's a great question. In fact, there were no permits. The DHCR, and I completely disagree, often doesn't require permits. However, we have in our papers stated there were permits for a lot of work, including work at that time in the building, but no permits in this case for an alleged substantial rehabilitation. If I may, since my adversary repeatedly references decisions, none of these decisions, Bazan, job estimate marked paid, and plus there was a registration. Canceled checks, invoice, Lowinger. Invoices marked paid and canceled checks, Park. Invoices and canceled checks and a trial, Fogarty, one of the main cases my adversary relies on. Invoices and canceled checks, Cohen. They don't have anything close to that, Your Honor. So at the very least.
Are those cases involve 14-year-old claim, a claim that 14
No,
years?
there are various periods from some
Yeah,
are 8.
none of them are even close to 14 years.
I don't know.
Right?
8, 10. There's no question, Your Honor, that in all deference that there's case law that's gone back that many years. If there's going to be, until this court or the higher court changes the fact that there's no statute of limitations.
I agree with you. I'm not saying that. You're pointing to the lack of invoices as some nefarious thing. That is what I am questioning, because it would not surprise me on a 14-year-old renovation that someone didn't have those invoices.
They found records for the little contractor. They found them. I mean, those were the landlord's records. They weren't produced by the contractor. They're produced by the landlord. So the landlord kept records for the $6,000 contractor, but no records at all for the $58,000 contractor. At least it raises a question.
Thank you, counsel.
The record does show a lot of information that was submitted by my client.
Is your adversary correct that for the primary contract, that there's less backup paperwork as opposed to the $6,000 contract?
I would submit, Your Honor, that there was an...
Is that just yes or no? Is that correct?
There, at pages 509 to 511 of the record, there are payment invoices. I cannot tell you if they pertain to both contractors or just to one of them. But in
Wouldn't it be the obligation of the landlord to say what invoices go to what contract?
I'm sure that my client's affidavit would have explained that, as well as the affidavit of the contractor, the principal of the contractor that actually did the work and confirmed the amount of money that was paid to his company. That might not be a, quote, payment invoice, but I would submit to Your Honor it's equally as valid. Very quickly, Your Honor, the one...
Well, I had one question. I mean, the fact that there were no permits, given the scope of the renovation, would not there have been some request for some work permit for the renovations?
At that time, I don't know what it was that the DOB required for these kinds of renovations, but I see no violations that were issued for this particular work. But Your
So
Honor,
you have 30 seconds. Go ahead.
very, very quickly, the one point that I wanted to emphasize to the court so that we can go beyond what the evidence was 14 years ago, look at what occurred subsequent to that. Not only were there 5 tenancies that were market tenancies, there was also 3 court orders that addressed whether this apartment had been deregulated. 3 orders indicated that the apartment was exempt and that challenges that prior tenants had brought on the ground that the apartment was stabilized were rejected. And that, Your Honor, I submit is most compelling in addition to the evidence of the IAIs that showed that this apartment was deregulated 14 years ago and cannot be challenged today as a matter of law. Thank you.
Thank you. Thank you both. People v. Abel Echeverria. Yes?
Good afternoon. May it please the court, Mimi Lee for the Legal Aid Society on behalf of the appellant Abel Echeverria. This court can and should reduce Mr. Echeverria's prison sentence to the minimum of 5 years in light of his substantial substance abuse history, severe mental illness, advanced age, and declining health.
So was the waiver enforceable, unenforceable?
No, Your Honor, the appeal waiver is not enforceable. The sentencing court fell completely short of its obligation in limiting its explanation of the scope of the waiver to only appellate claims arising from trial errors.
So you state in your brief that it's unenforceable because the court failed to mention that defendant's current claim, a challenge to his sentence stemming from a plea deal and not a trial, would be waived. Do you have any authority in support of that position, that the failure by the court to so inform the defendant would render the waiver unenforceable?
Well, Your Honor, there is no set litany required by the trial courts, but it is settled law in People v. Thomas that the trial court must ensure that Mr. Echeverria had a full appreciation of the consequences of the waiver, and the trial court did not do that here. By only explaining the right to appeal as related to issues stemming from trial, it is mischaracterizing the appeal waiver as one of the many rights automatically extinguished by a guilty plea.
Well, a conviction can be by trial or by plea. I haven't seen any cases, and I found your argument intriguing because I've never seen any cases that distinguish between a waiver of a right to appeal from a plea and a waiver of a right to appeal from a waiver of a right to appeal, I guess, from a trial, where you're talking about basics as to well, first of all, there wouldn't be a waiver of right to appeal from a trial, right? It would only be from a plea. So I didn't understand what your argument was, that a defendant would have to be informed that there's some difference.
Well, Your Honor, I would just submit that in order for Mr. Echeverria to understand the full nature and consequence of the waiver, he needs to understand what he's waiving. And if he's not going to trial, then he wouldn't be bringing up any appellate claims that are related to trial, and the trial court could have deducted that as it was taking its guilty plea. And this court is not barred from reaching the merit, as even though the trial court's cabining its explanation to only trial
So
claims.
what would be the merits in this particular case? Was this a stranger assault? A stranger attempted robbery, right? He approaches someone from behind, 1:55 in the morning, and he demands money. When she refuses, he repeatedly strikes her to the head with a screwdriver, causing multiple lacerations, etc. And so he's sentenced to 7 years plus 5 years post-release supervision. And so your position is that the 7-year sentence was excessive and he should be sentenced to what?
To 5, Your Honor.
To 5 years.
Yes, Your Honor, that is my position. The circumstances of this case are critical. The first critical fact is that prior to this offense, he severely suffered from running out of medication. The records indicate that he was taking 3 forms, one for anxiety, allergies, and the third being...
Allergies?
Yes, Your Honor, but the...
So medication for allergies caused him to engage in this? I mean, I'm just thinking people have to be careful, right, if they take medication, right, if they take medication for allergies. It is allergies.
No, Your Honor, it's just the third being an antipsychotic medication in which this break from his regular dosage of medication... I'm sorry, Your Honor, I see that my time is up.
You can complete your thought.
This break was so severe and so damaging that it decompensated him to the point where he had to be admitted to the hospital. And the time frame from when this offense occurred to his release from the hospital was so recent that Mr. Echeverria still had his hospital admission wristband on. Your Honor, would you like me to finish or continue
You
on
can
rebuttal?
certainly do that on a rebuttal. Thank you so much.
Good afternoon, Your Honors, and may it please the court, Andrew Chung on behalf of the respondent and the people of the state of New York.
What's your view about the waiver? Did the court adequately explain the distinction between trial and appellate rights, et cetera, et cetera?
Yes, Your Honor. The court effectuated a valid appeal waiver. The appeal waiver itself turns on 3 key issues here. First, the on-the-record acknowledgments. The judge in this case explicitly stopped the colloquy at multiple points to ask the defendant if he understood what was occurring, and the defendant responded in the affirmative. Moreover, as the record demonstrates, the judge in this case explicitly told the defendant that the appellate rights that he would be giving up were, quote, separate and distinct from the trial rights that would normally be given up upon a plea of guilty. The second key factor that goes to the appeal waiver point is the written waiver. In addition to the on-the-record acknowledgments, the defendant signed a written waiver which explicitly stated that the defendant was choosing to give up his appellate rights in exchange for a favorable bargain and after having a full opportunity to discuss the matter with his attorney. And given that he signed the waiver and his attorney signed the waiver, the only reasonable inference there is that that the defendant did in fact go over it. The third key issue to take into consideration as to the appeal waiver is the favorable nature of the plea bargain itself. As a predicate felon with 4 other robbery-related felonies on his record, the defendant was looking at a potential maximum sentence of 15 years in prison had he gone to trial. Instead, he received 7, which is just 2 years above the minimum. The extreme bargain he struck weighs in favor of this being voluntary. But, Your Honors, as an initial matter, I would like to discuss the particular facts at issue in this case, which are particularly heinous, and a sentence should not be reduced in the interest of justice. It's important to note just how serious the facts in this case are. As Your Honor mentioned, the defendant came up behind a woman in Hell's Kitchen and demanded money from her. And when she refused, as many of us rightfully might, he struck her in the head repeatedly with a screwdriver, leaving multiple lacerations. The defendant then stood over the victim and screamed at her as he smashed a glass bottle into the ground. Now, for this crime, the defendant received a sentence.
Counsel, did the defendant have prior convictions?
Yes, Your Honor. The defendant had prior felony convictions. He had 4 prior robbery-related felonies, and I believe 6 prior felonies overall. In addition to that, he had 5 misdemeanor felonies. And as I mentioned, the defendant received a sentence of only 2 years above the minimum, which is more than just given his criminal history in this case. Moreover, as a predicate, as I mentioned earlier, the defendant was facing a maximum sentence of 15 years in prison. Instead, he received just 2 years above the minimum. Finally, all the factors that my friend on the other side cites as relevant or potentially mitigating to this appellate court were already taken into consideration by the sentencing court, and they likely contributed to the leniency of his sentence in this
And
case.
even during the allocution, the judge questioned the defendant as to whether or not he was taking any medication. He stated that he was taking medication. He had taken his medication prior to the plea, the allocution, and I think he said he was feeling good, something of that nature, meaning, you know, he was okay to proceed with the plea.
Yes, Your Honor, that's accurate. And I believe they even went further, and the court stated on the record that it appeared to her that the defendant appeared lucid, and I'm paraphrasing there.
I think she said alert in
Alert.
response or something of that nature.
Yes.
But I was going to ask that question. In the any pre-sentence report or anything of that nature, the court was made aware of the defendant's history and also with the medication that he was taking.
Yes, Your Honor, that information was included in the pre-sentence report by the Department of Probation. And if there are no further questions, we would rest on our brief and ask that you affirm. Thank you very much.
To respond, the facts of this case do not warrant the maximum. In fact, the number of mitigating circumstances here call for a reduction in this case.
What was the maximum sentence he could have received in this case?
The maximum exposure was 15 years.
15 years. And so 2 years above minimum. Isn't counsel correct that in all likelihood the court below took into account some of the factors you've raised, including his mental health condition, lack of medication, and all that?
Your Honor, this court does have the authority to reduce a sentence that is untethered to the plea bargain and without deference to the sentencing court. I would submit that the sentencing court's questioning of the defendant's alertness and whether or not he was taking anything that would inhibit his judgment was so that he could be proper allocated.
So you talk about mitigation. Do we consider, was the court correct in considering the fact that the defendant had 6 prior felony convictions, including ones for attempted robbery in the 1st degree, attempted robbery in the 3rd degree, possession of controlled substance, et cetera?
Your Honor,
I'm sorry, and also 5 prior misdemeanors. I forgot those.
Mr. Echeverria's predicate status is reflected in his sentence, and we're asking for the minimum of the range of his predicate status, which is 5 years.
Thank you.
Thank you. Oh, I'm sorry. Thank you.
Thank you both. Bear v. Bear. Is it all right? Yeah.
Good afternoon, Your Honors, and may it please the Court, Adrian Koch from Katsky Corns for the defendant. And because the parties' names were anonymized in the published version of the lower court's order, I'm just going to refer to him that way without using names. But I want to emphasize that the issues on the defendant's appeal are not about matrimonial law. They're about statutory construction and contract. And I'm going to start with the statutory construction issue. The parties agree that because the defendant was unrepresented when the judgment of divorce was entered, DRL 236B6 required the court to ensure that he was given some information before it entered a judgment.
So do we consider the fact that on multiple occasions, everyone told the defendant that he should get an attorney?
That is undisputed, Your Honor, but the fact is he didn't have an attorney, and because he didn't have an attorney...
He can't be forced to get an attorney. They keep saying, you should get an attorney, you should get an attorney, you should get an attorney. And he doesn't get an attorney.
Right.
Do you force him to get an attorney?
But because he didn't have an attorney, the statute imposed certain obligations on the court.
Counsel, the provision that you're relying on, doesn't that only apply where the parties do not actually have an agreement unlike this case where the parties do have an agreement.
No, no, Your Honor, and I'll tell you why. And it's as a matter of statutory construction, the section that we're relying on has to apply regardless of whether there's an agreement. And this is the
What
reason.
about the language, except where the parties have entered into an agreement?
Correct. That's
Are you
in
reading that out of the
that's in
statute?
sub A, but there's a statutory construction analysis, and I'm going to walk you through it. It's on pages 34 to 37 of our brief. But in substance, the statute makes clear in subsection E that where the court itself is determining maintenance, that is where there's no agreement, the court has to set forth what the guidelines would be.
But it wasn't just determining.
That's correct. So subsection G is 2 sections later, and it says that if either party is unrepresented, the court can't enter a judgment with respecting maintenance without informing the unrepresented
Why
party.
does that apply in a situation where the parties have entered into an agreement and the judgment is simply incorporating the agreement that the parties have already entered into?
Because in subsection E makes clear that if the court is determining maintenance, the parties will be informed.
Okay, but that doesn't respond to the subsection that applies here, which is the subsection where the parties have an agreement. But we agree that that is what is the situation here. The parties have an agreement.
The parties had an agreement.
When the parties have an agreement, the statute says that is not necessary, correct?
No.
Well, what does that mean then?
The statute says in subsection G.
No, let's go to the section that says except when the parties have an agreement.
But I'm trying to explain why if you do not apply subsection G when the parties have an agreement, then subsection G is surplusage. And you can't read the statute that way. And the reason is because if the parties don't have an agreement, subsection E requires the court to compute what the guidelines would require and to award it unless it can explain why it's awarding something
But
different.
one's referring to the entry of judgment and one's referring to a determination.
Right, but
Why
in
is
the
it surplusage then?
it's because if the parties don't have an agreement, then there's no need for the statute to provide in subsection G that they have to be informed of the guideline amount, because by virtue of subsection E that will have happened already. And
So let's assume that we don't agree with that. Let's move on from that. Let's assume that we think the statute means that if you have an agreement that you don't, the judge doesn't have to do that. If that is the case, why should we void the party? Why should we not have the parties comply with that agreement?
With the agreement?
Yes.
Well, so we have a separate argument, Your Honor.
Right.
That
That's what I guess I'm trying to get to that.
Okay, yeah, so we have a separate argument, Your Honor, that the agreement itself is unconscionable.
Okay, why would it possibly be unconscionable?
Okay, unconscionability, as we all know, has 2 prongs. There's procedural and substantive. And turning to procedural unconscionability first, what the record reveals, and I want to emphasize as strongly as I can that the defendant's testimony in this regard is unrebutted. What the record reveals is that his former lawyer, who unbeknownst to him was actually living with the plaintiff at the time, specifically encouraged the defendant not to focus on the agreement and assured the defendant that he, the lawyer...
Diamond?
I'm sorry?
Are you talking about Diamond?
Yes, correct.
Okay, but doesn't Diamond send an email to him saying, I am not representing you in this matter, and I'm assisting your wife? So how can he possibly have relied on anything Diamond could or could not say to him when Diamond made it clear that he was not representing him in this matter?
First of all we're arguing is that we've raised enough to create an issue of fact.
No, but we have an actual email where Diamond says that to him. So that's documentary evidence that's unrefuted that Diamond told him, I'm not representing you.
At the beginning, but the defendant's testimony...
Well, not only at the beginning, but back to my initial point, again, also said you should get an attorney. I mean, not only did he say I'm not representing you, he also said you should get an attorney also.
And there are
And I also want to state, in the agreement itself, your client specifically stated that he acknowledged that it was fair and equitable and that he had entered voluntarily and it was not the product of overreaching or undue influence.
Right, but at the time, he did not know that, and his testimony that his former lawyer nevertheless gave him advice and encouraged him to rely on it, as he had done for years, for decades, is unrebutted, even though his former lawyer assisted the plaintiff in preparing her papers. But he didn't know when he signed that his former lawyer had misled him about what the agreement provided, had misled him that by telling him that.
You know, I think we're beating a dead horse. Diamond made it very clear that he wasn't representing your client, so it's very difficult for me to accept that argument that it was Diamond was the bad guy here.
Well, I guess all I would say is I would urge the court to consider that there is substantial, detailed affidavit testimony from my client in the record about the specifics of what Diamond did, and there is silence on the other side, even though Diamond was helping them with their papers. He says nothing to rebut what my client says in pages and pages and pages of affidavit testimony, and all we had to do here was raise an issue of fact.
As opposed to an email that was contemporary. Why wouldn't you look at the contemporary email as opposed to an explanation now when your client, even though has been told to get a lawyer, doesn't get a lawyer? He
sent an email, but then after that, he said, because there were constantly, he said, I'm not going to represent you in negotiating the agreement. But the relationship between these two gentlemen was such that this lawyer, oftentimes when he wasn't representing my client, gave him advice anyway.
But he not only told your client that he was not going to represent him, he specifically told him that he was going to advise the wife.
And he, in fact, also did not tell my client that my client had the right to object to that on the ground that he had been my client's lawyer.
He told him to get an attorney. As I said, we're beating a dead horse. You have time on rebuttal.
Thank you, Your Honor.
As you said.
May it please the court, Paul Talbert and Bernadette Schneider of Donahoe Talbert LLP on behalf of the plaintiff, respondent, appellant, Eleanor Beer.
Counsel, I'm sorry.
No, I just wanted you to address the statutory argument.
Yeah, I was going to ask you to do that as well.
I think we all want to hear that.
Yeah.
Sure. So as the court pointed, I apologize. As the court pointed out, there's express language in DRL 236B that says, except where the parties enter into a complying agreement. That's number one. There is a strong public policy, as this court has held over and over again, of parties resolving matters between themselves. That is another reason. And also, even assuming for the sake of argument that there was the requirement that the court give notice, there is a specific finding by the special referee in the judgment of divorce and in the findings of fact, which Mr. Beer signed himself, as well as the form judgment of divorce, that he did receive notice. And the special referee finds that the requirements of DRL 236 are met. He cannot come 2 years later and say, I disagree with that. There is no appeal. He just stopped paying 2 years later and said, I want to redo. Let's assume for the sake of argument that he's right. As he admits, there's a valid agreement here that he acknowledges is fair and reasonable, that the special referee has found specifically that the maintenance provisions are fair and reasonable at the—
Can you address the substantive unconscionability arguments? Because that, I imagine your adversary will address that in reply. Is there anything unfair about this agreement? The parties are married for 28 years. The wife hasn't worked, taken care of her children. The husband retains his business. Is there anything unfair about this agreement?
Could you repeat the
Is there
last
anything unfair from a substantive point of view that this agreement is unconscionable?
No, Your Honor, and to look at the bad faith of Mr. Beer in making that claim, what he's saying is this is unfair, specifically the maintenance provisions, because I should be getting maintenance from my ex-wife, because in this agreement, I got to hold on to millions and millions of dollars of capital loss carryforwards, which when I apply it to real income that's coming in, I now report zero income. Not that I didn't receive income, I get to report zero income. And as a result of that, for example, my $400,000 in income counts as zero, and therefore my wife, ex-wife, who I know really hasn't been working, should be paying me maintenance. That is, as the DC Court of Appeals said, is a splendid new example of chutzpah by Mr. Beer.
I was just going to say, is that chutzpah?
Did Mr. Beer negotiate the agreement?
Yes.
So it wasn't a situation where he was presented with it and said, sign it, correct?
No, Your Honor, not at all. As you see,
Did he make his own? I'm sorry, go ahead.
There's an email as part of the record where he lays out all of the points that
Counsel, when you're negotiating the agreement, did you also advise him to get his own attorney?
I advised him to get an attorney multiple times. Mr. Diamond advised him to get an attorney multiple times. To the extent that he raises these fantastic claims about confidential information being passed along, okay, and doesn't really explicitly say what they are. He is told, Mr. Diamond tells him, I don't represent you. He tells him, I will be speaking to your wife in connection with this to help resolve it. Mr. Beer sends an email giving us information, laying out the points of the agreement, laying out the tax issues, the business interests, the fees, and at the end of this email, he says, I have copied Dave Diamond, who can attest to the accuracy of what I have described above, and then comes to the court and says, I can't believe that some information was given by Mr. Diamond to my wife, when he said, go to Mr. Diamond and confirm everything that I'm telling you. That's in the record at page 554, Your Honors. I see my time has expired. If you have any other questions.
No, Counsel, you had a cross appeal, but you didn't ask for any time on the cross appeal. Did you want time on the cross appeal?
Yes, Your Honor, very, very briefly,
Okay,
I
so
apologize.
afterwards, I'll give you time on the cross appeal.
Very simply, it's...
After counsel, you can get time.
Thank you, Your Honors. I know I only have 2 minutes, so I just want to try to address a couple of things that were said about the agreement. First, on the sharing of information, one of the other things that Mr. Diamond did, and it's in the record, is that in his capacity as general counsel of the defendant's company, he had access to the company's emails. And while the agreement was being negotiated, and while he was living with the plaintiff, cohabiting with the plaintiff unbeknownst to the defendant, Mr. Diamond repeatedly used his credentials to access the defendant's emails and repeatedly searched for emails about the plaintiff.
So, counsel, could you respond to the question asked by my colleague of your adversary? In substance, substantively, how is this agreement unconscionable? How?
Yeah, the substantive unconscionable, sure. So the record shows by the time the parties divorced, there was one meaningful marital asset. And we believe, and we don't want to get into name calling, but it was because the plaintiff spent all the parties' money. They had one meaningful marital asset
Well, that's
left.
not getting to name calling at all.
Okay. Well, they had one meaningful marital asset left, and it was an interest in a business. And the plaintiff received 63% of that asset, and the defendant got 37% of that asset, plus the plaintiff got the right to 50% of the defendant's distributions from that asset. So she got more than 80% beneficial interest in the party's only meaningful asset. And the reason why she...
only meaningful asset, I'm not sure what that means. Is that the only asset? What's the asset?
That's all they had.
Hold on a second, let me finish.
Sure.
What is the asset that allows your client to get whatever he's getting? Is it
His
through his
employment.
business, right?
His employment, yes.
His business.
Yes. Right, that's correct.
And so why wouldn't the plaintiff be entitled to that, to at least some of that?
Well, so the parties had an ownership stake in the business. And she got 63% of their ownership stake, and he got 37% of their ownership stake, plus Unbeknownst to him, because Mr. Diamond told him the agreement meant something different, she got a right to 50% of his distributions from that asset, in addition to the 50% of his
You keep
salary.
saying, Mr. Diamond, your client is sophisticated. I thought he was a business person who, I think he went to Harvard or something. He's familiar with various things. You're stating that because Mr. Diamond tells him, that he's going to get something other than what he's actually going to get. He doesn't understand this. He doesn't know to do the calculations or to understand exactly what's going on.
The agreement specifies that each party is entitled to complete and sole ownership of the share of the business that they're getting. And my client thought that meant that he got to keep his distributions. And Mr. Diamond told him that's what it meant, that all she was getting was his salary.
I know we keep trying to pull Mr. Diamond in all of this, but I don't,
Did he, when he was told to get a lawyer, did he get a lawyer?
He didn't, and the reason is
Did
because
he, it doesn't matter why, he is a sophisticated person who was told to get a lawyer. He knows what it means when it says, this is fair, and I agree that it's fair, nothing unclear about it, and he signs it. And then a couple of years later, he says that I didn't agree, I didn't want it, I negotiated it, I specifically turned down a lawyer, and I signed not only the agreement, but a statement in the agreement that says, I understand that this is fair and equitable. And you're asking us to vacate that?
our position on procedural unconscionability is because he was actively misled by his former...
So Mr. Diamond tells him all these various things, and he agrees with it. But Mr. Diamond also tells him to get an attorney, and that he says no to.
Well, because he didn't have the available funds to do it at the time.
Oh,
I thought that the reason was that he didn't want to spend the money.
Yeah.
No, that was my recollection.
Yeah,
of the
I
record,
thought in
but-
the record it was that he didn't want to spend the money, not that he didn't have the monies. But again, that's really not, I guess, that relevant. But thank you. So again, you have time on your cross appeal. I'll give you 2 minutes.
Thank you, Your Honor. I'll be very brief. In connection with the money judgment, the language of the statute is clear that it's not discretionary by the court whether or not to issue a money judgment. There was proof that plaintiff was entitled to a money judgment, and Judge Waterman Marshall explicitly found that she was entitled to a money judgment. There was no good cause shown for why Mr. Beer did not comply with his obligations.
Just a question about that.
Sure.
Legally, you may be correct, but there's a true-up provision in the agreement in terms of how if there are issues with respect to maintenance are resolved, how does that impact on the judgment? If the true-up is exercised at some point.
Does not impact the money judgment in that the court specifically found the amount that was due.
Well, that's outside the true-up, essentially. That wouldn't be covered by that.
In terms of this, the way it was procedurally litigated, yes. And then getting back in terms of the income execution, they're two separate enforcement mechanisms with very different purposes. And if Ms. Beer were held solely to the income execution, because she's entitled to 50% of his distributions and income for the next 10 years, and she's only granted 5% more with the income execution, it's going to take forever for her to recover the amount due. Mr. Beer essentially has an interest-free loan until such time as can be recovered, and Mrs. Beer is losing out on the statutory interest that she should be getting and accruing the cost to Mr. Beer for not actually paying the money judgment. Unless the court has any further questions, Your Honor.
No, thank
I'd
you.
rest.
Thank y'all.
May I be heard on the cross?
Yeah, I'll give you one.
Thank you, Your Honor. First of all, the court did not find a dollar amount due and owing as of November 10, 2021, which is the amount, which is the date as of which they want a judgment. And the reason why the plaintiff was not entitled to the judgment she asked for, which was $70,857 allegedly due as of November 10, 2021, is because by the time the order was entered, the income execution had been in place for several months, so at least some portion of the amount due as of November 10, 2021 had been paid, and the lower court had no way of determining what that was because the plaintiff didn't submit any evidence of it. So as a result, the best the lower court could do for the plaintiff was exactly what it did, which was deny her application for a money judgment without prejudice. The plaintiff chose not to go back at any time with evidence of what was actually outstanding, and the simple reason why this court shouldn't enter the judgment that she's asking for is because it's clear that some portion of it's been paid, and in fact, based on the standard principles of how a court should apply payments that the defendant's been making now for over a year, it's likely that the entirety of whatever was outstanding.
So wouldn't the appropriate language be, if we agree with the plaintiff, that maybe it's less sums recouped from the income execution so that there's no double recovery?
Well, I would respectfully suggest, Your Honor, that that is not what the plaintiff asked for in the cross appeal. The only relief the plaintiff asked for in the cross appeal is the $70,000 judgment that it's clear she's not entitled to. She has the right, because it was denied without prejudice, she can go back to the lower court at any time and seek a calculation of what's actually outstanding after the defendant's been paying this income execution for over a year. And that would be...
How much has he been paying?
I don't know the dollar amount, but it's 55% of all of his income.
Thank you.
Thank you.
Van Horn versus Ben Dove.
Good afternoon, Your Honors. Matthew Hurl for the appellant. In granting summary judgment, the trial court labeled the business justifications that were offered for pursuing the merger as pretext. She concluded that there was a personal animus, and that was the compelling reason for pursuing the merger. However, context, and we believe the record also...
So let's go back to the time of the merger. Okay, so at the time the merger was proposed, what evidence do you say supports your position that Zohar exercised business judgment for a bona fide corporate purpose?
At the time of the merger?
At the time.
Yeah, okay. At the time, the genesis of this, again, was the phone call that Mr. Green had made to Zohar asking that he provide false testimony in his divorce case. Or, alternatively, the possibility was that Veronique, his soon-to-be ex-wife, would gain control of the shares, which she was actively pursuing.
How can you rely on that, though, when it's undisputed that she didn't get any interest in...
Well, Your Honor, that determination came in October of 2020, 4 months after the merger was pursued. At the time when Mr. Green approached Zohar and said, please present this affidavit, which we submit would have entailed false information. Alternatively, Veronique is trying to get the shares from the trust, and if she gets them, she's not going to be a cooperative partner.
So did your client articulate that at that time in any fashion?
Well, the information...
Or was it was in his head and
it wasn't from his head. He went, when Mr. Green approached him, he went to attorneys and he said, what do I do about this?
Okay, great.
And
did you submit an affidavit from an attorney saying, well, he came to me, we had these conversations, some are privileged, anything that would substantiate the position that you're taking today?
No, we submitted the affidavit of Mr. Bendov, who said, I went to attorneys, they told me we don't have a shareholder agreement. This exposed this as a problem, 1, for capital contributions, and 2, for no restraint on transference. And because if Veronique, at the time, which was still a very good possibility, if Veronique got the trust asset, the shares, they could have been put into a situation where the subchapter S status of the corporation was destroyed. She could have sold them to a third party.
It was 5%? 5% of the...
It was 5 to 7.
Like that. It's
yes,
something very, very small amount.
Doesn't matter, though, Your Honor.
Very small amount, right?
If any shareholder of a subchapter S is not qualified, it destroys, as a matter of law, the subchapter S status, and that would expose the corporation to taxation, and it would impose millions of dollars.
Were those maybe plausible explanations given at the time of the merger? Is there any documentary evidence, communications, emails, that would corroborate what your client is now saying?
Well, no, there was nothing, there was no documentation submitted, but Mr. Green was aware because he was the one who raised the prospect of the problems that would result if Veronique got control. He's the one who raised the specter of the problem. And so Mr. Bendov, who's 84 years old and getting his real estate holdings in order, now all of a sudden has tumult visited upon him by the existence of these shares and the exposure that these shares could then lead to a multitude of problems for the corporation. So he goes to the lawyers.
So let me say this. So they go to a meeting, right? And he asks him, why is this? And what does your client say?
He says it's duly
Duly
your questions
noted,
are duly
right?
noted because
So
this is
at
not
the
a question
time-
and answer.
At the time, no, there's nothing like that. He says 2 words. The meeting's transcribed. Duly noted, duly noted, duly noted. Doesn't say anything about any shares. Doesn't say anything about any lack of a shareholders agreement. Doesn't say anything about any of
That's true.
that. Then he puts in a literal 2-page affidavit on the motion for a preliminary injunction, which basically said, I didn't want the tumult. Nothing about lack of a shareholders agreement. Nothing about what I didn't want to get involved in their divorce.
No,
and
Your
the
Honor,
lack of
to correct Your Honor, he does say it was made clear to him that she was making a claim for the shares.
Okay, she was making a claim.
Yes.
Right. That was his reason for a freeze out.
No, his reason
Yes,
for the
that's
freeze-out
what is
was the
that
business-
somebody was making a claim on the shares.
Yeah, and the consequences of that.
Are there any cases that you can show to me where someone makes an amorphous claim on shares that would justify a freeze out?
I can show you the cases that say where a subchapter S's corporate status is threatened, that is a proper business excuse to.
That may be well, counsel, but it's like, you know, the horse has left the barn or whatever leaves the barn. It's kind of late to make those arguments now, or at really when you made them was at summary judgment is what my colleague was alluding to.
Well, they were made at summary, yes, to be entirely.
Well, no,
candid.
but
The
no,
summary judgment motion-
but this was known to you at the time when your adversary made an application for injunctive relief. That would have been, it seems to me, the time to put all that in then, as opposed to at summary judgment, when it appears that your client's just trying to come up with justifications.
I'm not sure that's the case, Your Honor. I think summary judgment is the point where you have a full record. Preliminary injunction on a week's notice or whatever it was for the order to show cause does not present the court with a full record. And the case law does say.
But you had the information at the time. But you have time on rebuttal.
Good afternoon, Your Honors. Peter Sluka for the respondent. May it please the court. The trial court below correctly held both.
What do you say about the argument that the legitimate purpose for the freeze out is the fear that the wife is going to take the shares? And that's what he expressed at the time of the meeting.
In the words of the trial court, I say that argument is rank pretext. There was absolutely no threat that Veronique could lay claim to any of these shares. Mr. Green's assets in the divorce were subject to equitable distributions, not the assets of the Green Trust. The Green Trust was not a party to the divorce proceeding, as the trial court recognized on the preliminary injunction stage. And
when
that was later
on
confirmed,
the
but-
preliminary injunction, did the plaintiff put in an affidavit explaining all this? Am I on the wrong?
Yes, that's exactly right. And additionally, I mean, this corporation specifically is indifferent. Even if in some alternate universe Veronique could lay claim to those shares, this corporation, which exists and will exist for the next 87 years to just collect rent and pay distributions whenever Zohar feels like it, is indifferent to Veronique owning a 2.5% share interest. So I think the trial court correctly held that the threat of entanglement with the divorce proceedings.
Was there anything expressed at the meeting? So you get a notice of a special meeting, and the special meeting is for the freeze out. the special meeting occurs, and was there any of that worry expressed at the meeting?
No, of course not. In fact, the
There
only
any of that
response was,
expressed in the affidavit in opposition to the motion for a preliminary injunction?
so before the affidavit, there's some other factual pieces of the record here. There was an email, and this is at page 261 of the record, where Zohar sort of foreshadows the merger. And again, there's no explanation of this apparent business justification. There was the merger documents, which were circulated that, of course, don't have this bona fide business purpose. And in broader context, this is one of 9 other freeze-out mergers that Zohar orchestrated in connection with their joint holdings. This was part of a broad decoupling because Zohar promised that he wanted Green out of his life. But to answer your question, Justice Scarpula, Mr. Ben-Dov, his affidavit in opposition to the preliminary injunction did say the threat of entanglement with the divorce proceedings for the first time there. And I think the trial court correctly dismissed that as after the fact, right, pretext, particularly relying on the transcript of the director's meeting, where presumably if that was in his mind, he would have said so.
Did he, at that time, at the preliminary injunction or the permanent injunction hearing, did any attorneys put in any affidavits saying that this was
No,
what I told him?
No, if you're referring to the affidavit that Justice Singh alluded to a few
Right.
minutes ago, no, none of that is in the record. The only thing that
And
is in the
actually
record
at the-
there is Zohar's affidavit.
Right.
And they attribute, the lack of business purposes in there to a hastily prepared opposition. I submit to you that's a euphemism for we haven't thought of these yet.
And then at the summary judgment stage, was there any, here's who I spoke to, here's when I spoke to him, I was advised that this was a possibility, even though I didn't say it at the time?
No, at the summary judgment
And in
stage,
fact,
Zohar had a
it-
chance to submit a complete record.
Right.
Certainly that was not in there, nor was there any explanation for the change of tune, the new business purposes now. The thing that was there at the summary judgment stage was the order from the New Jersey Divorce Court confirming what everybody knew all along, that Veronique had no chance to those shares.
Okay, thank you.
And I think that adequately explains what was in Zohar's mind at the time he initiated that freeze-out merger, and that is the subject of this inquiry. But the trial court also went a step further and said, we'll consider the justifications offered, and based on those justifications, they are also insufficient because they don't state a bona fide corporate purpose. I see my time is up. I'm happy to conclude, or
Thank you.
I would reiterate that up until the decision by the New Jersey court 4 months after the fact, only then was the claim to the trust shares determined. And so,
But was the trust, as your adversary makes a good point about the trust, the shares were in the trust. Was the trust a party to the divorce proceeding?
it was not a party to the divorce proceeding, but
So did
shares-
your client get legal advice saying that in these circumstances the shares in a irrevocable trust would be subject to the divorce proceeding?
the shares were, so the judge in the New Jersey case addressed the trust
No,
and
I'm
said
talking
claim
at the
was
time
there.
of the merger. Did you get advice? Did your client get advice with respect to that from an attorney?
Yes, he consulted attorneys who said that the possibility was there that if Veronique succeeded in her claim in the New Jersey divorce and obtained those shares, then the consequences of that
Again,
for
did
the
you get an
corporation
affidavit,
would be dire.
from an attorney saying that?
There is no affidavit in the record from an attorney saying that.
Thank you. Thank you both.
Thank you.
Lucas versus Verizon. Yeah, proceed.
May it please the court, I'm Randall Levine for the appellant, Verizon Media. The commercial division erred below because it assumed that if the party's non-compete agreement was unenforceable, that automatically means that Verizon committed a tortious interference with business relations when it told Mr. Lucas that it intended to enforce the non-compete agreement. And that's wrong because it conflates two very different legal standards. And the problem is that for a tortious interference with business relations, there's two requirements. First of those requirements is that the plaintiff has to show that there was wrongful means employed. Wrongful means conduct like a crime or like an independent tort. And the other requirement is to show.
The threat to enforce a non-compete, would you say that's wrongful means?
No, it's not. In fact, in this court held in the Pagliaccio case, that a threat to bring litigation, and in that case specifically a threat to enforce a non-compete agreement, is only wrongful means if the threat is frivolous, meaning it has absolutely no legal basis.
Discussions where there was some doubt expressed about the enforceability of this non-compete under the circumstances. Why isn't that enough in this case?
I'm not sure that that's a correct characterization of the record. What's in the record is that there's some back and forth among business executives among Verizon about whether the non-compete would apply or not. But those were businessmen, and so they were not.
Was some doubt expressed there about whether it was enforceable, though?
Yeah, that's not the same as asking whether it's enforceable. The question that they had was whether the positions would be competitive. And at that point, they didn't know all that much yet about the prospective position with Warner Media. But as we later learned, there actually was quite a bit of substantial overlap between those positions. So at that early stage, before anything else had really happened, they were considering whether the non-compete would apply. Later, it was determined that it would. Because they determined that, they advised Mr. Lucas that it would apply and that they would enforce it if he took the job. It turns out that he never did take the job. So it's actually not this court's job to decide whether or not, in that hypothetical scenario, the non-compete would have been enforceable. The only question is whether.
Because it was withdrawn, though, right? The job offer was withdrawn because of the threatened litigation.
Well, I think that might overstate some of the record as well. The record shows that Warner Media withdrew its offer because there was in place a non-compete agreement. In fact, Warner Media had identical non-compete agreements with its own executives.
Also, not just the non-compete, but that there was no assurance that there would not be an attempt to enforce it.
Well, it's not that there was no assurance that there would be no attempt to enforce it. At least no attempt not to enforce it against Warner Media. The only threat, to even characterize it that way, but the only enforcement would be against Mr. Lucas, and that's also very clear from the record.
Yeah, did Verizon speak at all to Warner Media?
Not once.
So there was no communication between, so the third party that you're supposed to interfere with, there was no indication at all that there was communication between those two.
That's correct, Your Honor. There was no communication whatsoever, and that is undisputed. It's also undisputed, just from looking at the record, that at no point did Verizon Media ever suggest in any communications to Mr. Lucas that it intended to sue Warner Media, nor is there any indication in the record that Warner Media was concerned it was going to be sued by Verizon Media. This was only about interactions between two contracting parties, between Verizon Media on the one hand and Mr. Lucas on the other.
And the discussions were we may enforce this against you.
Correct, Your Honor.
Right?
Yes.
No indication that there would have been a suit against anybody else.
That's correct, Your Honor. And under the Carvel case.
Well, however, if Mr. Lucas did take information to Warner Media, which Warner Media did in fact use, then would Verizon not possibly assert a claim against Warner Media?
There's no evidence that Verizon intended to do that from this record.
But could Warner Media not draw that conclusion?
We don't know what conclusions Warner Media might have drawn from that. But that's certainly not a part of this record, and any conclusion along those lines would be nothing but speculation. But we also do know that Warner Media informed Mr. Lucas that because he was not able to represent to them that he was free to take this position, that is why Warner Media took the job offer off the table. It was because he was unable to represent that he was not bound by a non-compete agreement. Under the Carvel case, that precludes this tortious interference claim as a matter of law, without even looking at the question of the malice exception or the wrongful means test. And for that reason, summary judgment should have been granted. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Damian Cavallari, counsel for respondent and plaintiff Jeff Lucas. This case is about a massive corporation improperly threatening litigation regarding an unenforceable non-competition provision.
So hasn't this non-compete been enforced in other jurisdictions?
In one instance, more than 10 years prior.
Has it been enforced? I should make it more general.
In a very different factual.
So, right, but it's been enforced, this non-compete. And no court has ever held in this case that the non-compete was not enforceable.
Well, the court in this case held that this non-compete was likely to be unenforceable.
I mean, that is something else. The
Your
trial
Honor, if-
court made a statement, but there is no ruling by any court that this is an unenforceable non-compete.
Right, there's only one ruling by one court that this is enforceable, at least as far as we're aware. But the issue,
And
if you
there
go
is
back to-
one rule, right, so nobody's ever said this isn't enforceable. No one has ever ruled, I shouldn't say that, I should be more general.
Yeah.
And so when you say this unenforceable, that's your view of it, right?
I understand. Your Honor. Let me explain one thing. The BDO case makes clear that every type of enforcement for a non-compete is very fact-specific. It's all dependent on the context. There has to be a legitimate business purpose underlying the claims to enforce
Counsel,
that
we
restriction.
don't need to actually decide whether or not the non-compete was or was not enforceable. We're just talking about wrongful means here. How could there be tortious interference where there was never even any communications between the employer and Verizon?
But Your Honor, this is the requirement is communications directed at a third party, not communications directly with a third party.
What is wrong with saying you employee voluntarily entered into a non-compete agreement, you signed it voluntarily, you knew what you were entering into, and we are considering enforcing it if you go and compete against us?
Well,
what is wrongful about that?
Well, what's wrongful is the fact that Verizon, despite having months of communications with Mr. Lucas in which he described the position, provided position descriptions, and extensive back and forth about what the position with Warner Media actually was, Verizon said, well, we're going to still threaten to enforce this, and you tell Warner Media that that's going to be what we're going to do. And if you want to resolve
What is wrong
this...
in that where he did enter into a non-compete agreement, which arguably could apply to these circumstances, and no court has ever found that it doesn't apply. So what was wrong with what they did?
Well, what's wrong is if you were to hold that as a matter of law, any individual that signs any non-compete, regardless of...
This person, I want to sort of take you back a bit. This person is not any person. He is a person who received $2 million in restricted stock for the non-compete. It's a lot of money. He's not a lower level employee. He's a pretty high level employee. So I'm not sure that that broad statement is correct.
Well, in this case, Justice Singh, the question really is, he didn't receive all of that money because it was vested over a period of time. So
But counsel, the question is whether it is frivolous to assert, right? So we have a high-paid, high-value employee who's represented by counsel when he signs the agreement with the non-compete, correct?
That is correct.
So this isn't somebody who doesn't know what he's doing. He understands what a non-compete is. He has a lawyer who is representing him when he enters into this agreement. And then how under those circumstances, how is there an issue of fact that it's frivolous to try and enforce it?
Well, Your Honor, to begin, New York law is clear as to the confines in which a non-compete can be enforced. It's not based on the terms of the non-compete. It's based on the legitimate business interests that are being protected by the non-compete.
Again, what evidence have you shown that it would be frivolous? Not maybe he might lose, but what evidence have you submitted to raise an issue of fact that it would be frivolous?
There are two specific pieces of evidence and one aspect of non-evidence. The two pieces of evidence are the first being Mr. Garapan, the CEO of Verizon Media at the time, saying, we're not here to do charity for people that are leaving within less than 2 years. That was him as to how they were going to respond to Mr. Lucas's departure.
You're saying that that statement makes a negotiated with lawyers non-compete frivolous?
Your Honor, the second piece is when this chief business officer was asked what was the factual basis underlying Verizon's threats to enforce the non-compete, his response was, I don't know. They should know what the factual basis is if they have a good faith basis for threatening to enforce the
He's not the lawyer
non-compete.
who's making the legal determination as to whether the non-compete was or was not enforceable.
You're right, Justice Kearns, but in this instance, Verizon does not assert an advice of counsel defense. They were not relying on the advice of counsel. They were making these statements on their own. This is based on primarily Mr. Markman's, I see my time is remaining, may I finish?
Finish your thought, please.
This is based on Mr. Markman's decision to enforce it, and he did not know what the factual basis underlying their threats were. That makes at least a factual issue relating to the good faith basis of Verizon's threats. Thank you, Your Honors.
Thank you.
Your Honors, I'll relinquish my time for rebuttal.
No, 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 I just want to ask you, what do you say as to those two pieces of information that counsel says raises an issue of fact as to frivolity?
I don't see how those two could possibly raise an issue of fact over frivolity. For one, whether a legal position is frivolous is a question for the court to decide, and clearly it's not frivolous. Whether or not a particular executive knows all of the underlying facts about a decision that was made.
But he's the one who would be making the decision, according to your adversary.
I don't think there's any evidence in the record that any one of these executives alone was responsible for making that decision. But I will say, however, that everything that the executive said was firmly rooted in Verizon's legitimate economic self-interest, right? They made very clear that the reason for invoking the non-compete agreement was because they were concerned about the competitive impact of Mr. Lucas going to a competitor. They also wanted to see if there was some way they could retain a valuable executive. They wanted to make sure that if there was some way they could maintain the team that he had developed and the revenue that they were generating, if there was some way they could do so. Whatever that is, it's certainly not malice, and the Carvel court makes that very clear as well. If there's no further questions, I'll relinquish the rest of my time. Thank you.
Thank you both. Lopez versus New York State Office of Children and Family Services. Oh, I'm sorry, that was submitted. Maria versus People versus, excuse me, I'll get it right. Diaz versus the State of New York. How about that one?
And Conti, right?
What about?
Did I miss another one?
Yeah, 47,
Okay.
547?
You call 45, 47-49 versus Conti. We'll try that one. Press it out.
Good afternoon, Your Honors. May it please the court. Paul Copy of Rose and Rose, appearing for the appellant. Before I begin, I want to apologize to the court for the fact that the record appears to have omitted page 6 of Justice Leibovitz's decision. If anybody needs it, I brought copies. Happy to hand them up.
We still don't know how to use NISIS.
I'm sorry? Still don't?
We still know how to use NISIS, counsel.
Okay, well.
We may be here, but.
With that said, I'll launch in. Your Honors, this case presents an abundant illustration of the constitutional infirmities of 22 New York City Administrative Code 22-1005. The contracts clause of the U.S. Constitution was originally designed.
Before we get into the substance of the constitutional argument, was any notice provided to the Attorney General below about the constitutional argument? And if not, how do we have the authority to address it on this?
Well, notice has been provided and filed. The
But was it provided below, or has just been recently?
No, it was only provided.
How do we have authority? Because our only job here as an appellate court is to look at what the court decided below. And if the issue is not below, properly before the court below, isn't the remedy at this point then to remand it and let the court make a constitutional determination in the first instance, and then we can review it once they actually make a determination on the merits with notice, with the input of the Attorney General?
Well, I would submit that even if the court were to fully embrace the constitutional argument, the case would still need to be remanded. So, perhaps a remand would be the provident choice. I will note that the Corporation Counsel, it's not really the Attorney General because it's a city statute, not a state statute. But the Attorney General not only was notified, but appeared on this appeal.
But counsel, isn't the city entitled to make arguments with respect to the constitutionality? And I think that's what my colleague is getting to. We don't have that record. So how can we really make a decision now in a vacuum without a full record, understanding what the explanation is at the city as to why this provision was put into place for that short period of time?
I think that the court can make a determination for several reasons. Number one,
On the constitutionality?
on the constitutionality, absolutely.
Although it
city-
hasn't been fully briefed and we don't have anything from the city?
You do have from the city. The city submitted a detailed,
It's an
lengthy amicus brief.
It's not a brief as a party with full representation. And normally, we are an appellate court. We review the determinations of the court below. We don't make independent determinations here in the first instance. And I actually believe there's another case where the First Department has remanded on this very
On the same issue?
constitutional issue.
Well, let me,
You want to address the other prong with respect to the 3213 relief you're seeking?
with respect to the
Yeah,
3213 proceeding? Sure.
there's some damages that you...
Sure. The better authority, which is cited at length in our papers, is that a guarantee that embraces an obligation for the payment of money qualifies under CPLR 3213, notwithstanding the fact that it includes a guarantee of other non-monetary obligations.
And we actually held that numerous times, the First Department, that very finding.
Yeah, I think that although there are cases that go the other way, there are a number of cases.
Are there, and is there undisputed amount of of representing those numbers that are outside, say, the period that is in contention about?
There are some undisputed amounts, and there
Right.
are other amounts that could readily be
So the
reduced.
brokerage commission, I'm sorry, the brokerage commission is some certain, right? That's not disputed?
That's a some certain.
Okay, with respect to I guess the balance, according to my notes, there's some balance for rent due under the lease. Is that disputed as well?
That is not disputed. The balance due under the lease is not disputed. The only thing that I understand to be disputed is the amount due under the acceleration clause. And I think the point is probably well taken that the respondent made, that under the acceleration clause, there is a requirement to provide some kind of credit, either for whatever amount of rent is deemed to be reasonable, or in the case where the premises have been relet, a credit for reletting. I believe they have, in fact, been relet, which would, under the lease, reduce the acceleration clause provision to purely a mathematical calculation. It would be the difference discounted at the present value.
In a nutshell, that's not a sum certain at this point.
It's not a sum certain at this point, but it could readily be reduced to a sum certain merely by mathematical calculation. And that's all that I understand the law to require.
Thank you.
Paul, do you want your notes? Oh, sorry. Thank you, Your Honors. Leonard Spinelli, Genova Burns, on behalf of the respondent. Let me just first point out that I agree that the record here is not sufficient to make a constitutional determination. Although the city has appeared, they did not appear below. There's no record of the factuals back. There's no record of the factual determinations that led to the passing of the guarantee law. All of those things should be adjudicated below. Now, with respect to the acceleration provisions, first thing
Before you do the acceleration provision, what about with respect to the brokerage commission and then the small balance left over in the lease? Are you disputing those amounts?
Water and sewage.
I don't think that they were in dispute, Your Honor.
Sorry?
I don't think that they were in dispute.
Okay, so you acknowledge that...
We acknowledge.
They would be entitled at least to a judgment with respect to about 38,000 or so.
Not, and I think that was the order of the court. It was not. Okay, I apologize. I'm confusing the different
That was on
amounts.
page 6.
That was on, yeah.
It was
Yeah, that
clearly
was,
intentional. Clearly
37
intentional.
Oh, okay.
So
we disregard that. So 37,875.81 water and sewer charges, and then the brokerage commission was not disputed, right?
I want to speak to the accelerated rent for a moment. On page 30 of the record, in the guarantee, in a standalone paragraph, notwithstanding the above, guarantor shall not be responsible for any accelerated rent or any accelerated additional rent. The plaintiff here cannot accelerate, and the court recognized that below, issued in its decision that notwithstanding the guarantee law, they were not entitled to accelerated rent, and we noted in our opposition papers that that piece of the judgment was not raised in the opening briefs. So we would submit that that issue is not on appeal, has been decided by the court, and should not be reversed. The other point I want to address is the question of surrender, Your Honor. Excuse me. Although it was not raised in the papers, the opening briefs, in the reply, the appellant then argued that there was no written agreement for the surrender of the premises. And I want to point to some very specific pieces of the record that the court should take into consideration if it decides to even address that, which I would submit that it should not. First, the provisions of Article 18 of the lease entitle the landlord, upon default, to demand the immediate surrender, vacation, and that the tenant quit the premises. Although the tenant sent a letter in April advising that in 6 months he would vacate and surrender, 2 months later in July, the landlord, in accordance with the terms of the lease, sent a demand in the notice of termination, a writing signed by the landlord demanding that the tenant surrender the premises by July 19th of 2020. On July 18th, the tenant complied and surrendered the premises. The case that the landlord cites in their reply brief essentially said that because the tenant in that case did not surrender, and that the landlord had to seek an eviction proceeding to take possession of the premises, that the tenant was therefore liable for the rents accruing after the date that the landlord or up to the date that the landlord relet the premises. Those facts are not present here. There was a writing by the landlord demanding our surrender, and we complied. So I would argue that there was an offer in writing signed by the landlord and an acceptance by performance by the tenant. Unless there are specific questions on the constitutionality, I can certainly get into them. It seems like the court's not prepared to do that. Unless there,
what is your argument about the applicability of Melendez? I mean, we have a finding that it's unconstitutional.
Certainly, Your Honor. I would point the court to the amicus brief, and I would point the court to the dissent in Melendez. The Second Circuit's decision in Melendez is a curious decision for a number of reasons.
No, but we have a subsequent decision by the district court.
Certainly, but
maybe the thing to do is just stay this and see what the Second Circuit says about the district court's determination that the statute is unconstitutional.
I don't think that that's necessarily a bad outcome, but I would perhaps urge the court to consider the arguments of the city and to consider the arguments raised in the dissent in its own independent view, because remember, the dissent in the Second Circuit would have dismissed it as a matter of law. And the reason why the Second Circuit or the dissent, Judge Carney, would have dismissed it as a matter of law is because
I mean, every court has dissenting decisions. No, but the decision is send it back for a fact-finding, and then fact-finding occurs, and the district court says it's unconstitutional, right?
And it's certainly persuasive authority, but I think the court could be equally persuaded by the dissenting arguments as well.
Thank you.
Thank you, Your Honor.
Thank you. I'll address the issue of what counsel characterizes as the surrender,
We need to get into that at this point, though. If we are inclined and we do end up remanding for the constitutional issue, isn't it premature to be addressing that at this point?
Well, even if you remanded for the constitutional issue, the issue of whether the good guy guarantee was ever exercised and the effect of the fact that the landlord terminated the lease will remain relevant until such time as it's adjudicated. And I think it's therefore worth recounting briefly exactly what happened. The tenant in this case, in April of 2020, gave a notice that it intended to surrender pursuant to the terms of the good guy guarantee. The terms of the good guy guarantee are 1, 6 months notice of intent to surrender, 2, payment of rent up until the time of the surrender, and some other conditions, but those are the two that are in play here. The second of those conditions, which was payment of rent until the time of surrender, was not honored. No rent was paid after the 6-month notice was given. That's why the landlord invoked the lease's conditional limitation several months later. It doesn't mean that the guarantor and/or the tenant could not still, at that time, have satisfied the conditions of the good guy guarantee. Same thing, by paying the 6 months of rent. That's the out. And the Melendez court noted that as well. The guarantor simply didn't fulfill the terms of the good guy guarantee, with the result that it was never discharged. And that's not affected by the fact that the lease was terminated. Terminating the lease did not relieve either the tenant or the guarantor of liability prospectively. It's set forth very clearly in fairly typical lease language. That argument, really, with due respect, does not avail the tenant or the guarantor here.
Thank you. Thank you
Thank you.
both. Okay, now Diaz versus the State of New York. Yes, whenever you're ready.
Good afternoon, Your Honors. Natasha Ayers on behalf of the appellant, Severo Martin Diaz. I'm here to ask the court to reverse Judge Seiss's judgment against the plaintiff in the amount of 30% and enter a judgment against the State of New York for 100%, based on the fact that Judge Seiss's findings of the fact were not based on evidence and was based on speculation, and quite frankly, was physically impossible.
But didn't he hear the testimony, made determination, and based on that came to, the split 70-30? Maybe others would do it differently. Why shouldn't we defer to that as opposed to exercising our right, which we do have, to make independent findings here?
Sure. Well, as a background, if you see the testimony of the defendant witnesses, theirs was completely inconsistent. Their deposition and trial testimony changed multiple times. But if you look at the photographic evidence, it's common knowledge in looking at the evidence, and the defendants agreed, and the judge agreed, that there was only dent damage to the plaintiff's vehicle. One large dent. 0 scrapes. The judge credited that testimony, looked at the photograph, agreed. The defendants themselves, both defendant witnesses, agreed that there was only one large dent. So if you have a car stationary, as the defendant claims it was, no matter what angle you put that car, once plaintiff goes by and, according to Judge Swipes, loses controls and hits it, and everybody testified the plaintiff kept driving in a forward direction, there will be some type of scrape.
How do we know that? Is there an expert affidavit saying that that's what would happen, or because of the biomechanics or whatever it is of the accident that there would be scraping too? I mean, can we?
There was no expert opinion.
Judge Below know that without expert testimony on that?
Because it's just common knowledge in our everyday experience and common sense. If something is going forward at 25 miles an hour, which Judge Seiss found the Severo Martin Diaz vehicle to be driving forward, and the defendant's witness and the plaintiff all state that he kept driving forward, common sense, there's going to be a scrape. This is consistent with and only supported by a T-bone type impact going forward, just as the plaintiff testified. His car was hit and he was pushed to the side, where then after he stopped his vehicle. So based on that, there is impossible for this accident to have occurred, have the defendant's witnesses said. On top of that, for the court substituted and made up a whole new set of facts. He made up a whole new set of facts. Here, he says the plaintiff.
Was the judge making facts or finding facts?
He came up with a new set of facts that were nowhere.
Well, he found those facts, right?
He found those facts by coming up with his own theory when there was no testimony in the record regarding it. If you recall, the plaintiff testified that he saw the defendant's vehicle at that stop sign before they took a left.
Well, there was some discrepancy where there was a town car or where there was a Crown Vic, right?
But ultimately, the police...
But, I mean, there was that discrepancy. He wasn't really sure. He kept referring to it, I think, as a town car, and it was actually a Crown Vic, right?
No, that's where you're wrong. The plaintiff always said when he took a left, the Crown Vic, which was in front of him at the stoplight, veered to the right to go into the southbound traffic, and he saw illegally parked in the median a shiny black Lincoln Town Car having nothing to do with the defendant. The defendant, Gomez, the driver, seized upon that and insisted at trial that she was driving a Lincoln Town Car, trying to make herself that car that was parked there. And then when we showed her the police report, and the state stipulated, no, you weren't, the state was not driving a shiny black Lincoln Town Car. It was a Crown Vic. She finally admitted, Ms. Gomez, the defendant driver, yes, she was driving.
So that's the point. So the judge now listens to the testimony of the plaintiff, listens to the testimony of the individuals in the Crown Vic, the defendants, and makes a determination based upon the testimony and based upon the photographs. What's wrong with that?
Because the photographs don't support that the plaintiff kept driving, lost control, and kept driving forward when there is a singular large dent, a circle like this, without one...
Well, that goes back to my colleague's question. Was there any expert testimony or any other testimony that one dent or whatever that you refer to is only consistent with the testimony of the plaintiff and was inconsistent with the testimony of the defendants?
There is no expert testimony in all in this case. I submit to you that that is just common sense. That you cannot go forward while you're driving, hit something and not scrape your car. It just can't happen.
Thank you. Yes, you may proceed.
So, counsel, I'm looking at the two pictures, and isn't it possible that the claimant took a turn, hit the side of his car, hit the front of the state's car, just the way the state's witnesses testified that it did?
Yes, absolutely,
You know, I'm
Your Honor.
looking at the pictures myself right here. I think that's pretty possible. But I think what the judge found was, unlike what your client said, she wasn't all the way in the sort of dead zone and was sticking out, and that's why when the claimant took the turn, the side of the claimant's car hit the front of her car, correct?
That's exactly correct.
Is that an impossible result?
No, not at all, and we haven't cross-appealed. We're not challenging that finding on appeal.
What about your adversary's position that it's common sense that there would be scraping, and therefore, I guess, the parole officer's testimony here is incredible as a matter of law in terms of their vehicle being stopped in that position?
Well, even if you accept that argument, you know, as we said in closing, there was plenty of evidence that was produced and that showing scrapes to the vehicle. And the judge himself talked about scrapes to the vehicle. He happened to conclude that those scrapes were not as the result of this particular accident, but the idea that there was somehow an absence of scrapes, and that is completely dispositive, is just untrue based on this record. I'd also like to point out that plaintiff didn't always maintain anything. In fact, his story changed quite a bit. He told the police that the cars were proceeding side by side when he was struck, and then, obviously based on the location of the accident, which was in the gore, between the gore and the cement wall, he realized that was impossible, and so in his claim he said, oh, they cut across the gore. And then at trial, he said, oh, there was this other vehicle, which I did not mention to the police, did not mention in my claim, that was actually parked in the gore, and they executed this
Is
very
there, is there anything in the police report about that vehicle supposedly in the gore? I called it the dead zone, but it's the gore. Is there anything in the police report about that?
No, there's not.
Okay. And your witnesses testified there was no third vehicle, and that they were the vehicle that was stopped in the gore.
That's correct, Your Honor. They consistently testified that the vehicle was stationary when it was struck. There was no, that was consistent through their depositions as well. There was no prior and consistent statement introduced to impeach that testimony. That was consistent throughout, that the vehicle was stationary. Unless the court has further questions, we urge this court to affirm. Thank you.
Thank you.
Your Honors, both the judge and the defendants and the plaintiff said there was no scraping along the side of the car. And the defendant witnesses, both of them, said they were just next to those water barrels right in the front. So how can my client have hit them and not struck those water barrels? That was all the testimony that was there. There was no testimony from anyone that the state vehicle was parked further back. And to Your Honor's point about the Lincoln Town car being not in the police report, referred to in the police report, it wasn't involved in the accident at all. My client said that they were riding parallel. He took a left, he was going at 25, they were next to him parallel, they drove to the right, and all of a sudden they must have changed their mind and came
I
to the
totally
left.
understand that, but the state's witnesses testified to something completely different. And the trial judge sifted through everybody's testimony, decided that for each party, part of it was correct and part of it wasn't correct. And we weren't there. This court wasn't there at the time, and there's nothing obvious at least to me, that would say that that sifting was incorrect or bad, except for your statement that there had to have been scrapes, which I accept that you think that's true, but without any expert or testimony from an accident reconstructionist, I don't see that, except for a lawyer arguing.
Okay, and our position is that it is just a matter of physics, common sense, that you would see every day. Something going straight, something hits it, while it's still going straight, it will be a scrape. Thank you, Your Honors.
Thank you. Thank you both. Last case for argument, People v. Kavan or Kevin Seals.
Good afternoon, Your Honors. Danny Green on behalf of Kavan Seals. This court should exercise its independent discretion and modify Mr. Seals' risk to a level 1. The RII purports to determine a registrant's risk level by combining his risk of reoffense and the danger that he poses to the community. Here, the evidence presented at the SORA hearing demonstrated both Mr. Seals' low risk of sexual recidivism and the lower degree of harm presented by a potential reoffense. First, his remorse and commitment to therapeutic rehabilitation showed a fundamental shift in his priorities and outlook.
But doesn't the RAI take that into account?
Your Honor, in terms of, the RAI does take into account conduct incarcerated under Factor 13. However, in this case, because Mr. Seals had, because he had a recent Tier 3 infraction, Factor 13 points strictly apply there, and any mitigating information regarding the totality of his conduct while incarcerated was not considered in that assessment.
I'm sorry, what was the last point you said about his incarceration?
I said that because Factor 13 points were strictly applied here because of a recent Tier 3, any mitigating information regarding the totality of his conduct while incarcerated wasn't considered in that assessment because it was strictly applied due to that recent Tier 3. Additionally, courts have found repeatedly, including this court, that there are instances where a registrant's rehabilitation reduces their risk of recidivism, such that a downward departure is warranted. Specifically, this court ruled that excellent rehabilitation is a mitigating factor that's not adequately.
So where is the showing of excellent rehabilitation on the part of this defendant other than his completion of the alcohol abuse and sex offender treatment programs, which were mandated and also which is required of other defendants as well.
Yes, of course, Your Honor, and I would say that the completion is, of course, not enough. However, exceptional work within the programs is. Here, Mr. Seals successfully completed a 12-month version of the sex offender treatment specifically designed for individuals struggling with chemical dependency. His evaluations reflect this. He received all scores within the highest ranges of highly motivated, and his counselors recognize his commitment to self-reflection and transformation.
That's kind of boilerplate, isn't it?
Your Honor, I would say that the comments in those evaluations demonstrate his good work. And additionally, I think something that's unique here is that the court was able to hear from Mr. Seals himself through a letter to the SORA court. And that letter specifically goes through ways that he was impacted both by SOCDP.
So what about the infractions that he incurred while incarcerated?
Yes, Your Honor. Again, he was assessed points under Factor 13 for this. And while he was admittedly involved in 2 fighting incidents while incarcerated, this is non-sexual behavior, and it's...
So it's a total of 6. 6 infractions, I believe. 2 were for violence, right?
There was one that was a Tier 3, 5 Tier 2s, and one of those Tier 2s was fighting, and then the Tier 3 was also
During
fighting.
2 years of incarceration. So he
Yes, Your
incurred
Honor.
6 infractions in a 2-year period of time.
Yes, Your Honor. Yes, that's correct. This was all non-sexual behavior, and I would argue that it's not a compelling indicator of any increased risk of sexual recidivism, especially what was already assessed by the RAI.
So, counsel, I just want to ask you, is it correct that defendant scored on the static 99 and that was an above average risk of recidivism?
That's correct, Your Honor.
So there was a test, right? And that was while he was incarcerated, right?
Yes, and numerous courts have highlighted the very limited value provided by the static 99. It's not the risk tool that was adopted by the board here. Instead, a different risk tool was created specifically because that risk tool takes into consideration the nature of the offense, which is a mitigating factor here, as well as any rehabilitation, which is, again, a mitigating factor here. So the static
I'm sorry, you said the nature, you mean the infraction in terms of the nature of offense was a mitigating factor?
No, Your Honor, I'm sorry, the nature of his underlying sexual offense.
Was a mitigating factor?
Yes, Your Honor.
What was mitigating about that?
Your Honor, my client was I'm sorry, one second.
He was 24 years of age, and he was convicted of fondling a stranger, a female, in Times Square, right?
Yes, Your Honor.
So I didn't understand, what's the mitigation on that?
As the SORA court acknowledged as well, in the context of registrable sex offenses, this one is comparatively minor. And the prosecution acknowledged...
Really? Who said that?
The court said, honestly, the nature of his offense here was serious, but as sex offenses go, we have seen much more serious.
Well, that doesn't minimize the conduct. I think it's common sense, as was stated by another attorney, that you don't fondle, that it is not trivial to fondle a stranger, 14-year-old, 12 years old, excuse me, a 12-year-old girl in Times Square. That's not trivial. I don't see any mitigation.
Your Honor, of course it's not trivial. I don't mean to state that in any way. However, what I am stating is that what is trying to be determined by the RAI here is both risk of reoffense as well as what the potential harm would be if someone were to reoffend.
So if you are 24 years old and you walk up to a 12-year-old child who's with a 13-year-old, another 13-year-old child, and you fondle that 12-year-old child, and then you incur 6 infractions while incarcerated in a 2-year period of time, I have to wonder about your risk of offense. But we can discuss that on rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court. Look, based on the offense itself and all surrounding circumstances, the defendant was correctly adjudicated a level 2 offender.
So what do you say about counsel's argument that his completion of sex abuse offender treatment and alcohol abuse treatment, in while he was incarcerated was not adequately taken into account.
Your Honor, I would say that it was great that he completed both of those programs, but he did not show that his response was exceptional to warrant a downward departure.
Was that taken into account in terms of the general?
Yes, his
How was that?
participation in both was taken into account. For sex offender treatment, I believe that goes under factor 12, and for, I believe for the substance abuse treatment, that goes under factor 13.
And that was taken into account?
Both taken into account
So
by the
was there
RAI.
anything extra that happened that in your opinion would have been more mitigating?
No, Your Honor, that would be more mitigating.
Yeah, I mean,
I think a stronger showing in regards to his sex offender treatment, and certainly not incurring the infractions that he did
Well,
while
what about the
incarcerated.
fact that the defendant did write a letter, I think, expressing his remorse? There was a statement to the court?
Yeah, again, in Your Honor, remorse is taken into account under factor 12. The RAI does contemplate expressions of remorse.
So you get a 0 for that if you express, you don't get any points if you express remorse or take responsibility.
I believe so, Your Honor, and he was assessed 0 points.
0, right.
And beyond that, again, some of what defendant has done is commendable, but it has already been taken into account, and he hasn't shown this court or the court below should have made an exception and granted a downward departure, because you are looking to see if there's an exception to be taken rather than going along with.
And there's no dispute that the assessment, the initial risk assessment was a level 2.
Correct. The parties all agreed that he was.
So he was a presumptive level 2. The issue is whether there should be a downward departure.
Yes, Your Honor.
The other thing was that he had no, I mentioned 6 infractions, 2 of which were violent. None of the infractions involved any type of sexual conduct.
I don't believe so. I will say, Your Honor, I'd just like to point out that in addition to the 2 violent infractions you named, he also, at the time of the SOAR adjudication, had a never pending violent infraction. That was his second tier 3 offense. And that was from June 19th, 2019 for, quote, assault on staff, unhygienic act, interference, harassment, and direct order violations. And that was recounted in the case summary accompanying the RAI. In sum, he was correctly adjudicated a level 2 offender. His downward departure application was properly denied. And if there are no further questions, we ask that you affirm.
Thank you.
Your Honor, I'm sorry, I didn't know if you wanted to finish asking the question that you had been asking.
Oh, I didn't have any additional questions.
Okay, I'm sorry. I just wanted to note quickly that in terms of remorse, courts have repeatedly recognized that sincere remorse does mitigate risks in ways that are not fully captured by the scoring of the RAI and can constitute a ground for a downward departure. Additionally, I just wanted to speak to Mr. Seal's score on the RAI. He was adjudicated 75 points, which is the lowest possible score in the level 2 range. And courts have recognized that where a score falls within a range does impact whether or not a departure is appropriate. I think the fact that if he had been 5 points lower on the RAI, he would have had a level 1 is meaningful here, especially when we've presented a number of mitigating circumstances that weren't fully considered by the RAI.
But isn't the counter to that the conduct, which maybe you're not trying to minimize, but was very serious because he groped a 12-year-old girl here?
Yes, Your Honor, and of course, one of the main things that the RAI tries to do is assess the nature of an offense in order to predict if someone were to reoffend, what that potential reoffense may look like. But the board itself has admitted that the RAI can't capture the nuances of every case, and courts have relied on the egregious nature of a registrant's offense conduct as an independent, aggravating factor warranting an upward departure. We're not asking for that here, but rather we're asking that this court, at a minimum, consider the less serious nature of his conduct, which is acknowledged by the court and was also acknowledged by the prosecution in allowing him to plead to a misdemeanor sexual offense here, and consider that as a mitigating circumstance in its totality of the circumstances analysis, particularly considering that he is just within that range of a level 2. The court at the SOAR level said that they were surprised to see, based on his offense conduct, that he was a level 2. It's very rare that someone with a misdemeanor sexual offense would be adjudicated this way, and that should be taken into consideration.
The quote-unquote non-egregious nature of this conduct is not acknowledged by me. But thank you both very much.